Jonathan, welcome to Wealth Talk.
Thanks very much, Chris. Thanks for inviting me.
No, you're very welcome. And it's probably a good place just to start by introducing yourself and what you do.
Yeah, well, I'm an IP practitioner. I specialize in trademarks, which means that I help businesses to to clear for registration and then to register their trademarks and brands all around the world, and then to enforce those brands and to keep clear water around the rights that we've helped them to get. And I've been in the business for 30 odd years, and I act for a wide variety of types of business across different sectors, from very large companies to a lot of SMEs and startups and small businesses too. So as a firm, my firm is active in the IP sector, predominantly in patents and trademarks, which are the two top types of IP, although we advise on all sorts of other IP related things too. But my particular speciality is trademarks.
Okay. Fantastic. So, we're talking about the intellectual property pillar at the moment, which essentially is taking some knowledge, some way of doing something, and then packaging that up to be of value to other people. So, some of the things that we've discussed under the IP pillar are writing a book or creating a course or a system that, as you say, you might be able to license to other people. What are the common types of IP outside of those that you deal with most, Jonathan?
Yeah, well, intellectual property, as you and many listeners, I think, will realize, is an umbrella term. It's an umbrella term for a variety of different rights which are available to businesses, some of which require you to go and register those rights, apply for them, and they have to be examined. And then if they're granted, you get your rights. Some of them just exist, and you simply have to prove that you own them in order to assert rights. But the main types are, first of all, patents. And a patent is something that protects an invention. So it could be a business process, it could be a mechanical object, it could be a medical device or a pharmaceutical or a vaccine. Essentially, that is protected by registration. And if you get your patent registered, you have exclusivity in that invention for 20 years, subject to renewals. So that can be hugely valuable if you have an important patent. I suspect that actually most of the people listening to this may be in a position where it's the second type of IP that's potentially more important, which is trademark registration. A trademark, and this is maybe the definition of a trademark may not be apparent to everyone, but a trademark is actually a very broad concept. It's essentially a commercial badge of origin which links particular products or services with the business that's behind those products and services. In other words, you see the brand and you think of the business behind it. You know that the brand is associated with that business. And brand is a very broad word, which sort of, the idea of a brand is it creates expectations in consumers of high standard and good quality products or a good delivery of a service. And that can then create reputation and then goodwill. And those things are tied in, obviously, with the value of a company. So trademarks, as they're used and as a business builds goodwill under those trademarks, can become extremely valuable assets. You do have to apply to register a trademark. It's not a rubber stamping process like registering a domain name or a company name. There's an examination that goes with it. And the reason for that is that when you get that registration granted, you can essentially enjoy a monopoly in that trademark, which lasts as long as you pay renewals, which is every 10 years, but there's no limit of term on a trademark. So once you've got it, and assuming it's a common thread in your business that is consistently used, it can become an extremely valuable right. And the other thing is that it's almost every business would benefit from at least one trademark registration protecting its core name or its primary brand or whatever. By way of example, a trademark could be a word, it could be a logo, it could have aspects of color that are protectable. A trademark can be the shape of a product, so some perfume bottles and distinctive drinks bottles have been actually registered as three-dimensional trademarks. Trade dress, so the way that a store or a business is actually set up visually, can be protected. Even sounds. Think of there's some quite annoying little ditties out there when you watch advertisements on TV. Some of those have actually been registered as trademarks because, again, it's a badge of origin. You hear that piece of music, you think of Direct Line or whatever. You think of whoever it is that is behind that. So those two, I would say, are the most important types of IP in most cases. But there's also a type of IP called a registered design, and that is also gives you a monopoly. So it's a strong right. A registered design exists in relation to the shape or appearance of a product. So it's kind of aesthetic aspects of. So if you have a distinctive sofa, for example, or a table, or that particular manifestation, it's not that the sofa is new, it's that your design of that sofa is new, and that would be outside trademark registration, but it would be protectable by a registered design. And designs also protect things like pattern and ornamentation when that's applied to a product. So you apply for those registered designs. In that case, the term is 25 years and is renewable every 5 years. So that's a bit like patents. It has a finite life. A trademark can be registered forever once you have it. And then the fourth and final one I would mention is the main type of IP is copyright. Now, copyright is not what we call a monopoly right. So it's not a type of IP that you have to apply for. If you are the author, in quotes, of original material or work, is the word used in the legislation, you're the author of a particular work, then you automatically own copyright in what you've created. And that allows you to stop unauthorized duplication by third parties. It applies to all sorts of things. It applies to books, to other printed matter. So, for example, literature about companies in their marketing collateral, for example, would be subject to copyright. Works of art, of course, music, computer software. There's copyright in the code, believe it or not. I mean, you actually have copyright in a phone directory. If you actually format the numbers in a certain way, you'd have copyright in that. And they're the main four types. I would just draw the distinction between what we would refer to as monopoly rights, which is where you apply for a piece of property to be granted, a registration around that piece of IP. That applies to patents, trademarks, and registered designs. And then other types of IP, which are sometimes referred to as property rights, are like copyright, where it just exists. But the big difference is when you come to assert your rights against a third party, if you're trying to go after someone for copyright, you have to prove that they actually copied you. If it's coincidentally similar, that's not enough. Whereas for trademarks, designs, and patents, the court doesn't care whether it's coincidental, accidental, or deliberate. You infringe. So it's a much more powerful right.
Yeah, that's interesting. And for anyone who hasn't been through the process before, Jonathan, can you just give us an idea of the costs involved, the length of time involved? Is it complicated?
Yeah, so I mean, let's talk about trademarks first, because I think that will be the most relevant one. So a trademark is, you register a trademark by going to the UK Intellectual Property Office, the UK IPO, and you file an application there in which you declare what your trademark is, i.e. you put a representation of it in the application form. You set out the products and services that your business wants protection for, because you obviously, at the end of the day, you don't get rights to use a trademark on any goods and services. You get rights on the goods and services you've actually specified as being part of your business or relevant to your business. So you specify those goods and services, and then the UK IPO examines that application on various criteria. It examines it, for example, on is it distinctive enough to be registered? And distinctive is a key word. I can illustrate that by giving you an example. If you take the word jigsaw, jigsaw is a very effective trademark for clothing products because there's no conceptual link between the word jigsaw and clothing. Whereas if you applied to register jigsaw for power tools or for puzzles, that would just simply be a description of what the goods are. And then basically you can't register the words chocolate biscuits if you sell chocolate biscuits because it's generic. So the whole thing about having a distinctive trademark, which is another way of saying a strong trademark, is really key. And that's where advice can help, actually, because at the beginning of the process, it's understandably a lot of people who don't have exposure to this kind of area would assume that the more you describe what you're doing in your brand, the better brand it is. It is almost true that it's the other way around. It isn't quite true because, of course, a lot of businesses come up with words that actually infer a connection with what their products and services are, but they don't directly describe them. If they directly describe them, the UK IPO will refuse the application. If they just allude to them or are sort of have some connotation that's relevant to the goods and services, you'll get your registration. But arguably, you won't have the strongest trademark. I mean, the best sorts of marks are either ones like Jigsaw on clothing where there's no link, or else invented words like Pepsi or Kodak, or where that there's a lot of potential then for growing that and making that into a trademark where you effectively have rights on anything once you've got enough reputation. So yeah, and in terms of time frame, the UK IPO would normally be a start to finish process of about 3 or 4 months, which includes a 2-month period where third parties have an opportunity to object to your application, which they might want to do because they have another type of prior right that they think you're in conflict with. And so there's an opposition process. The vast majority of applications are not objected to. And, actually, if you do the due diligence before you file a trademark application, which we'll come on to later, then you're minimizing the risk of getting a problem. So in the absence of problems, it's going to be 3 or 4 months from start to finish. In terms of costs, I mean, that's linked to how many goods and services you want to cover. They're divided into lots of classes. That's another reason why a little bit of advice can help you, because you can get, someone to tell you. If, for example, you have a retail platform that sells clothing products, an online, web business that sells clothing products, well, you would want to cover the sale of clothing, which would be in one class, but you'd also want to cover retail services as a service rather than as the delivery of products. And you might want to cover, things like the sale of advertising space within your web platform, where you might want to be able to sell space to third parties. So there's things around the scope of the application which are where I think a little bit of help can be a good idea. But in terms of cost, for if you're just filing in one class of goods or services, then it's going to be of the order of, between about £600 or £700 start to finish, including government fees. That would be if you used someone like us to help you. You can file applications as a company on your own. You can file them yourselves, but I'm just saying that you need to be a bit careful about it's in the business's interest to frame the application in an optimal way so that you're preserving your position in other countries for later or whatever it may be. There's a number of things around that. But it's not a high cost process. If you get into third party issues, it can be more expensive, but obviously at any given point you have the opportunity to walk away and choose another trademark. On that point, I'd just make one other comment, which is that it's generally speaking much better to you basically sorry, I just slightly lost my thread here. This bit will have to be edited. Anyway, I'll come back to that in a minute. So essentially the cost is quite low overall, and that gets your trademark registration in the UK. Beyond that, of course, there's the thing about trademarks is they're jurisdictional by nature, so you're not getting worldwide rights for that. You're getting rights in the UK, and if many of the WealthBuilders clients are UK focused, that's fine. But obviously, there's the question of the European Union, the US, other countries, and there are various things that you can do to optimize your position in those countries. That gets more expensive, but of course, if the business is successful, that's justified. And a lot of our clients would be registering at least in the UK, the EU, and the US, and often many more countries for the bigger companies.
Okay. So clearly there's a benefit in having the trademark or the patent so that someone else is not going to copy you. Are there any other additional benefits, Jonathan, to protecting your IP?
Yeah, there are. First of all, as I alluded to earlier, a trademark is a piece of intellectual property. When you get a registered trademark, that is something that can be bought and sold. So it's an asset of the company that has a value. When you first file a trademark and you haven't really used it, it's an unused mark, but this is what you intend to do. So you get your registration in place first, which is the best way to go. Then at that point, the inherent value of that registration, may not be hugely high. It's still high in the sense that you've claimed that trademark from that date, and anyone else trying to register the same or a similar trademark to yours will find that your one's in the way of it. So you've got an advantage over competitors in that sense. But as you then launch your product or service and you use it and you get a reputation, that's when the goodwill grows under that trademark registration. And that's when the value really starts to ramp up. Because remember that a trademark registration is a monopoly right. It gives the owner a monopoly in that trademark, and not just that trademark, but any trademarks which are legally similar, in quotes, to that trademark. And that is potentially very valuable. So that's one other advantage. Another thing is that as vis-a-vis third parties, as your reputation grows under a trademark, actually there are a raft of other rights under that registration which open up to you. There are rights which are granted by the UK Trademarks Act only for trademarks which are registered and which have reputation. For example, if you're Pepsi, if you own the Pepsi trademark, one of these rights would be to enable you to stop third parties from using the same mark, even if their product area is totally different. And that only comes with reputation. It stands to reason you shouldn't have that very wide right unless you have a reputation. But with Pepsi, if you saw Pepsi on a bicycle, you'd assume that there'd been some commercial tie-up with Pepsi as a minimum, and you might be wrong on that. Maybe the bicycle's a terrible bicycle and everyone falls off them and they fall apart. And that then doesn't reflect well on the brand Pepsi. So Pepsi would be interested in that because they can assert themselves across the board. So that's another benefit.
Okay. Are there any downsides in not taking steps to protect your trademarks?
Yeah, I mean, the big one, and this is counterintuitive to a lot of businesses, but the trademark law regime in the UK and indeed in the EU is basically that the rights in a trademark, with one or two exceptions, go with the first party to register that trademark, not with the first party to use that trademark. So that means you could use the trademark but not bother to register it. And in that period, before you've realized you should register it, someone else comes along and registers, let's say, the identical mark. It would be for you to knock them off that position then. I'm not saying it would be impossible to assert your rights, but you'd have to prove that at the time they filed their application, your prior use gave rise to what's called a passing off right, which is not a registered right, it's a common law right, but which is a very high evidential burden and horribly expensive to prove. So, in a sense, if you neglect to register a trademark, you open up to third parties getting in with intervening rights, which might then be a block for you. So that's one thing. The other thing is it's harder to build value in a brand without a registration, simply because the registration is a tangible asset. Well, it's actually an intangible asset, but it's an asset of the company, and there is a specific registration there that can be bought and sold. With goodwill, it's a much more nebulous thing. It's harder to define, and it often attaches to trademark registrations and becomes tied up in the value of the trademark. And that's an easier way to quantify it and then to effectively leverage that value.
Mm. You mentioned due diligence earlier, Jonathan. Now we have a Wheel of Wealth at WealthBuilders, and that's education, support, connection, due diligence, and action. So due diligence, very important for any asset. Talk about the importance of due diligence when it comes to intellectual property, please.
Yeah, and it's a very important area, this, and I hope that this will resonate given what we've been talking about up to now. As a preliminary thing, I would just stress, and this is sort of due diligence, we'll come on to the other points in a second, but this point about your trademark being distinctive is actually part of the due diligence if you think about investing in your business. Because if you choose a trademark that is, number one, easier to register, and number two, easier to enforce than one that is not distinctive, then you are going to make the whole cost around developing that brand less expensive and the trademark will be more valuable to you at the end of the day. So I think it's really important at the stage when you're creating your brand to actually think about coming up with a trademark that is in fact distinctive. Okay, so let's assume you've done that and you've got your trademark. You at least you've identified what you want to monopolize with a registration. The next question is, are there any pre-existing trademark rights or indeed other IP rights out there which would give you a problem, which would in fact be an infringement risk if you launched your trademark in the face of that pre-existing monopoly right? And the way to tackle that is by means of doing primarily trademark searches of the relevant trademark registers, which is where all these rights are listed. There are two levels of this. The first is where you check essentially pre-existing identical or near identical trademarks to the one you want. That can be done pretty cheaply. For several £100, you can have a good look at anything that is a direct hit or anything that is nearly a direct hit. If any of those types of trademarks come up, then you haven't actually launched your mark yet, then the best thing to do is to choose another trademark at that point, because you don't want to launch a trademark or a brand because you like the trademark, knowing there's a potential issue, and then spend loads of money trying to defend your position. It's much better to go back to the drawing board and think, let's find one that no one else has. So the purpose of an identical search effectively is to prove a negative very cheaply. It doesn't, however, prove the positive. And the reason it doesn't prove the positive, by which I mean that the trademark is secure for you to adopt, is that trademark rights extend to similar trademarks as well as identical ones. So there could be similar pre-existing trademarks, not identical marks, but similar ones, that you would miss if you just did a quick identical search. So we call these searches full trademark searches. And that would be where someone like me would conduct that search for you, get the best possible data in, and then essentially write a memo or a note of any tangible, significant infringement risks that are there, with advice as to whether this is worth trying to get round or whether it's a fatal risk. Those sorts of searches can cost, they would cost £700 or £800 upwards to, I've had them where they've been as high as 1,500, but the norm would be between 700 and 900 or 1,000. And that would give you actually quite a high level of comfort around that trademark before you embark on the registration process and before you launch and spend lots of other money on it.
Mm-hmm. Okay. Now, finally, Jonathan, I know you had a comment to make for anyone perhaps thinking of registering outside and doing some business outside of the UK following obviously Brexit situation now. What's your thoughts there?
Yeah, Brexit does have an impact on trademark rights, and the reason for that is that as of now, even though we've left the EU, as you know, we're in a transitional period where everything remains as it always has been for the time being until the earliest 31st of December this year. So as a member of the EU, we currently benefit from a thing called the European Union trademark, the EUTM, which treats the whole EU as a unitary country, just one country, and you can get a registration with unitary effect across all 28 jurisdictions, including the UK. So, to any company as of now that was interested in trading not only in the UK, but also in one or two or more other EU countries, it would be highly cost effective to file an EUTM rather than a UK, because it covers the UK. But of course, the moment we actually leave the EU, then any company wanting to do that is going to need a UK and an EU trademark. So that's an important distinction. It's not. I think it just focuses the mind a little bit more on whether that additional cost is justifiable, as with any piece of expenditure like this. The costs are not enormous, but and the reason the EU one is so good is because typically, if you file in up to 2 or 3 classes, your filing fee is going to be about £1,200, which includes an official fee of €700 or €800, and that gets you an application across 28 countries. So you can see that in comparison with the UK, where it's £500, £600, £700 in a few classes to file, that's very, very good value. So that's one consequence of Brexit. The other way round, if people listening to this if they already had an EU trademark now, then on actual Brexit, there will be an identical UK right, backdated, mirroring the EU one, that is created on Brexit Day at no cost to the owner, So they will have like a cloned right given to them, for which they don't have to pay. So they're okay. People have got an EU one already.
Right.
But if you haven't got anything at the moment, you just need to be careful about filing in both jurisdictions after Brexit.
So the big lesson, Jonathan, is really don't waste any time. If you're in business, if you've got something of value, then you should really just start now.
Absolutely. And the other piece of advice that's really key is, if you can, you should try to do your due diligence and get your trademark application filed before you actually launch or soon after you launch. The point is that once you've launched and you're using the trademark, but you haven't filed, you are technically vulnerable to an intervening right getting in the way. But I realize it's not a perfect world, and there will be people listening to this who think, well, I've been using my trademark for a while and I haven't registered it. Does that mean I'm in terrible trouble? Well, no, it doesn't necessarily, because you will have built up some passing off or common law rights by virtue of your use. So you're not completely without rights. And also, you might just be lucky. There may be no intervening rights. It's just that, it gets more complicated if there are.
That's great. Jonathan, thank you so much for sharing with us today.
It's a pleasure. Thank you.